Today we are going to be talking about a case that could potentially bring about national reciprocity. All right, so you may remember several months ago, I did one of these videos involving a case in Massachusetts where an individual who was an out-of-state resident brought a firearm and was carrying it concealed in Massachusetts. He was arrested and subsequently prosecuted for having a firearm concealed on his person without having a Massachusetts concealed carry permit. He actually won that case. And the argument that was made at the district court level, and this is now being appealed, but the argument that was made by the district court was that there was no methodology for this individual to be able to receive a concealed carry permit in Massachusetts, since he was not a Massachusetts resident, and since Massachusetts doesn't grant permits to non-residents, therefore his Second Amendment rights were fundamentally abrogated. Interestingly enough, at the time of the Bruin decision, I turned to my law partner and I said, I believe that we now have national reciprocity. Now, I was candidly focused primarily on California. The Bruin decision, Justice Thomas is very explicit. He says that the Second Amendment exists outside the home. And as a result of that acknowledgement, someone needs to have the ability to exercise their Second Amendment rights outside the home. Well, in California, like Massachusetts, California does not grant CCW permits to non-residents. There is no methodology for someone to be able to carry a firearm in California if they are not a resident of California. Now, interestingly enough, in that decision, Justice Thomas opines that assuming a state allowed for open carry, that could be a legitimate pathway. It doesn't have to be that they only have to have the ability to concealed carry. They have to have some way of being able to exercise this specifically enumerated fundamental right. If a state were to say, fine, go ahead and openly carry your firearm, that would be a pathway. California, however, does not allow for open carry of firearms, nor, as I mentioned, will they grant a permit to a non-resident. So someone visiting into California does have the ability to keep arms. They can have firearms in their hotel room, I suppose, but they don't have the ability to bear arms outside of their domicile, not until they ultimately choose to become a California resident. Now, there are no other fundamental rights that become bifurcated upon crossing state lines. It would seem completely disingenuous to suggest that someone who happens to live in Nevada loses half of their First Amendment rights when they come into California. Yes, you can engage in freedom of speech, but you are not allowed to worship as you choose. Since you're not a California resident, your right to practice a particular religion is suddenly abrogated. That wouldn't make any logical sense, just as if they were to suggest that parts of the Fourth Amendment do not accrue to someone who happens to travel across state lines. And yet, the argument has been made that the Second Amendment, well, that can, in fact, be halved, right? Yes, you can keep arms, but you're not allowed to bear arms because we simply don't have any legal architecture that would allow you to do so. Now, personally, I had a vision in my mind. I had expected that I would get a client who had unlimited financial resources, lived in Las Vegas, was a cardiologist, coming into California to perform, heart surgery on conjoined twins. And since he happened to have a CCW in Nevada, he naturally assumed that that CCW would be recognized in California. After all, pursuant to privileges and immunities, other documents that he acquired, other licenses that he acquired in Nevada are recognized in California. So he drives at a high rate of speed to perform this life-saving surgery. He ends up getting pulled over by a California Highway Patrol officer, fully discloses that he's in possession of his firearm, and is subsequently arrested for having a firearm in his possession concealed without having a California permit. And then he would say to me, Stephen, I want you to litigate this all the way to the Supreme Court. And then we would end up having this, watershed legal event that would give us national reciprocity. Unfortunately, that wasn't the case that I got. The case that I got was a 22-year-old kid out of Idaho who had roughly $175 in the bank and had come to California with his firearm, carrying it concealed, to meet a girl. Well, ultimately, we did prevail on that case. Unfortunately, while we made our argument that the Second Amendment effectively precluded California from preventing this individual from being able to carry concealed because there was no way for him to carry concealed legally, we thought we would lose at the motion level at the trial court. And this would give us our pathway to make our way to the Ninth Circuit Court of Appeals and ultimately to the United States Supreme Court. The judge actually agreed with us at the trial court level and ended up dismissing the case. So that one got killed off. Well, the Firearms Policy Coalition, one of the leading civil rights groups in Second Amendment jurisprudence, has filed a lawsuit called Hoffman v. Bonta. And they are seeking a motion for declaratory relief, effectively making the identical arguments that we made in our case, saying, hey, someone coming into California is precluded from exercising their Second Amendment rights. There is essentially only two ways that this can be rectified. Either the California legislature can create a new code section that allows for the issuance of out-of-state resident CCWs, or alternatively, get rid of CCWs altogether in California. Now, I don't suspect that that will happen. All right, guys, I'm going to pause this video for just a second. So the sponsors of this video, USCCA, they're doing a giveaway right now, and it's pretty cool, right? You can read all about it in the description directly below this video, but you're going to want to get on it very quickly. It's going to end soon. All right, with that, let's get back to the video. But honestly, I think it's a lawsuit that has absolute merit. It has been filed in the Southern District of California. And for those of you who have paid attention to other large tickets, Second Amendment cases, you probably are well aware that the Southern District of California happens to be where Judge Benitez resides. And there is at least a possibility that this case may ultimately make its way to his courtroom. We'll have to see. In any event, it's something to watch. This is not something that's going to be relegated exclusively to California. There are, in fact, other states that have similar schemes where they don't allow non-residents to be able to carry concealed in their states. And I would suggest that that is an absolute violation of the Second Amendment. So this one's just starting. We'll have to play it out and see where it ultimately goes. But it's an exciting development and something that we should be happy about. In any event, if you have questions or you'd like to contact me directly, you certainly can do so at stephen@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.